Well, welcome to Hot Topics when medical conditions impact work. And we're all here because we deal with this all the time, right? And really thankful to have everyone here today. It seems our topics attracted a lot of attention this month. And first of all, I want to apologize to everybody because we just kept having conflicts with our usual date. And Felicia and I were just talking about we've had to reschedule several times. And we will still try to get back on our next schedule for November. And normally we wouldn't do a December. We usually go dark, but I think as you all know now, we have a very important announcement. And Felicia, we're going to miss you. So thank you, everyone. So we're going to do a December thing and celebrate in a good kind of way. I'm going to miss you a lot. So
I love working with you too.
Okay, we have some very interesting topics today, and we're doing the format a little bit different today because we're going to deal with some live cases first. As always, we try to bring our experiences with school districts throughout Southern California to the attention and minds of all of you so that we can learn from what's happening, some do's and don'ts, some best practices, things like that. And then we are going to wrap up with a couple of top level cases at the EEOC, Equal Employment Opportunity Commission level to give us some idea of what's happened at the Fed level, because we certainly know this last year has been chaotic at most, and a lot of impact on employment law and so forth. And there was a lull because even the EEOC director was discharged, and we're seeing things back up in terms of filings and rulings and things like that. So just to give you some idea of where we're going today, the first topic will be word of mouth limitations. What do you do when employees are talking about their medical condition but haven't brought it to the attention of HR? And then our second one is when temporary accommodations go way too long. And in the hot water, it can actually place you as a district in, but also how does the EEOC think about this? And we've got some suggested practices that others do that you might be interested in learning more about. And then of late, I've had a couple of really interesting situations, not work related, but they are progressive medical conditions that people have that we can see the progression over years. One of the cases we'll be talking about, an IPM was first done way back in 2011, and we're back again, but conditions change. So I've got some updated guidelines, recommendations from the Job Accommodation Network for how to think about these things and what to do differently. And then lastly, again, we've got two cases from the EEOC level, and I'll leave you, Felicia, to the one's Walmart, and the other one I all of a sudden blanked on that one. What's the name of the other case that we were talking about today?
It's fun. It's a wine company, Cheerwine Bottling Company.
There we go. Yeah. Yeah, and again, we'll talk about some of the missteps that perhaps these employers have made, or maybe where the employees have failed to reach the EEOC standards. So let's get going. And just as a reminder to everyone that the podcast is being recorded, we generally get the recorded episode out to my YouTube channel generally within a week. And so then it'll be available for you to listen to again, pass, share on. Again, it's all about learning from each other as far as the kinds of unique situations that we've dealt with. And I know I've said this before, Felicia, I believe you've agreed with me that particularly since COVID, I've seen more unique situations than I have in my 35 years of doing this. And that's where our world is, our society is. And when I'm not going to say necessarily that there are more things happening, but we deal with things more effectively and more efficiently. And just because we have something that happens to us doesn't mean we have to stop working. And I like to say I do a lot around cultural competency in the workplace. And guess what? Disability is one of the biggest cultural components of our work. And guess what? This is one area of life we all have an opportunity to enter at some point. Yep. Yes. Okay, so let's get going. Word of mouth limitations. I know, Felicia, you have a situation to share, and then I also do similar kind of thing, but a little bit of different outcome.
We get great questions, so this is a real live situation coming. We just protect all the names from, so I'll just go ahead with the question. Our cafeteria worker has started telling her coworkers that she cannot lift boxes, use a can opener, and cannot push the food carts. These are all part of her essential job duties. The coworkers feel that she's not doing her job as they are doing it for her. This employee has had many work comp claims in the past, so we hope these actions are not an indication that another work comp claim will be filed. My question is, can we request that she have a physical taken? I am asking this before we have a meeting scheduled with her. Such a good question to unpack. And we were talking before we started about this is knowledge. The question of what is knowledge and when do you know something? Even though this isn't to a supervisor or a manager, this is still knowledge, right? It's coming to them and seeping to them almost from it's coming from complaints really from the coworkers about
Mhm.
them having to carry the job duties that she's telling them that she can't do.
Yes, absolutely. And to emphasize the knowledge piece of it, as an employer, and particularly in HR or risk management, you have more knowledge about what you should be doing as an employer. And so once you have knowledge about an employee's medical condition, it's imperative. It's essential that you take action because of the potential risk of harm or injury to the employee, but also the risk or harm to others that could happen. But then also the real emphasis is on, wait a minute, accommodation is about trying to restore someone to performing all of their essential functions, not to remove them, and not for employees to self-determine what they can and cannot do without an interactive meeting. Yeah. And so that was a great question that school district put out. And again, they already took action. They're going to have a meeting, which is
Mhm.
great. And
Mhm.
again, this is a perfect venue. The interactive process was designed to be that under the ADA and the California Fair Employment Housing Act, is to provide that confidential venue to talk about medical issues at work, because otherwise we don't do that. But when it starts to impact attendance, performance of essential functions, et cetera, like that, then it's an essential conversation. Yeah. And
Right, and for an employee to remove the job duties themselves without having any conversation with their manager. And I told her this information is not notice of a work comp claim. This is
yeah,
not what we would consider going to your supervisor or manager or saying that I've been hurt. But certainly that conversation, that would be part of the meeting, right? That they're going to have. They have to interact, right? They've got to start because I consider this a first step of request for an accommodation. Even
yeah.
though it isn't couched that way and it isn't framed that way, that's what I consider all of this. Help me,
Mhm.
I'm having some kind of physical problems that I can't do my job.
Yeah, yeah, and that's such a good point, Felicia, because I've had many employers, public and private, who've said the employee didn't ask for an accommodation. I'm sorry, the employee doesn't know all this stuff. And for many of you who've used me in your IPMs, is that I'll say to employees, a lot of times people like you may not even know that this process exists, but it's been around for 35 plus years. And it's not their job to know these laws. It's your job in HR and risk management. And so, yeah, when you hear people start talking about, oh, I can't do this, or I'm having trouble with this, bingo, that's a red
Mhm.
flag. Better schedule an IPM. And on that note, Felicia, as I said, I had a situation to share, is that an employee was hired, she passed probation, and then it became known to the director of transportation, she was a bus driver, that she was openly acknowledging her condition of ADHD. Well, HR had no knowledge of this. The director said he didn't know. And so the meeting was held for two reasons. One, what's going on with ADHD and how does it affect your bus driving duties? And then two, are there any concerns about performing essential functions? And so it was a great conversation, went very well. And the employees, I never knew about all this. And so she had ADHD all her life, but never diagnosed till about 5 years ago. She had
Mhm.
successfully worked as a bus driver in other locations. She has trouble with focus and then time
Okay.
management. Again, alarm. As a bus driver, both are
Mhm.
pretty critical. But she was performing all the essential functions. In fact, she was the kind of person, partly because of her ADHD, that she actively volunteered to help out, chip in, be wherever she could be because she loved her job. And
Mhm.
but there was no problems with pre-trip inspections. There was no problem in maintaining her bus route on time. Kids loved her. Everybody loved her. And yes, she has a medical condition. Yes, she talked about it openly, but it was being managed through medication, and which she took during her work. And I clarified that the medication doesn't impact any of her cognitive faculties that could
Right.
interfere with driving. So everybody walked away. Okay, deep sigh of relief here is that we now know we've done our due diligence and we've clarified that the situation is well under control on medication. The employee has been asked to provide medical documentation to confirm the existence of the medical condition, but also that she's on medication to manage it. So she's self-managing her situation. But yeah, knowledge. You hear something, act on it.
Yes.
Great, good. Okay, so I know this one, we run into this a lot, and when temporary accommodations go way too long, now what?
So I'll do a little background and then we'll both talk. This case really, this is a real claim and this is a work comp injury. No names for privacy purposes, right? This injury occurred in June of last year, so a little over a year old now. This is a lead groundskeeper with a right shoulder injury. I believe it's a tear of a tendon. Temporary work restrictions for a long time from the treating physician of no lifting over 30 pounds. And then it wasn't on the note, but it should have said with the right arm, because the right arm is the injury or the injured body part. And this is a key employee, I would say, and they were able to temporarily accommodate in the current position, and they did this for over a year. And they do not have, they are working on their board approved return to work with timeframes. So they deal with cases on a case by case basis. And so that's just what happened. And the time just got by them, right? And then it was over a year. And then the doctor felt that the patient wasn't going to get any better, that he reached MMI and made him permanent and stationary with a note that said no lifting over 30 pounds, in which the claims examiner then sent the note and information about you have the 60 days to set an IPM. And there was a lot of good questions around that. They said, when does the 60 days start? Does it start when the doctor made him MMI, the report date? And I said, no. And they said, when Athens sends us the work restrictions? And I said, no. And the permanent work restrictions were the same, right? The note didn't change. And then 3, is it when, so the answer to that question about the 60 days to hold the IPM to fill out the employer offer of return to work, it's 60 days from the date Athens receives the permanent work restrictions, not the date the district receives them and not the date that the doctor's report. And then they said, okay, he's MMI. Now, is he still eligible for the 60 days of IA leave? Because they never paid him IA leave because he's been working light duty, accommodated duty all this time, temporary accommodated duty, which is now they need to have a meeting. And I said, no, normally 60 days of IA leave is for people that are on temporary disability. He's no longer temporarily anything. He's permanently disabled with permanent work restrictions that per the doctor are not going to change with future medical care and rateable permanent disability. And then an IPM was set, and then there were a lot of twists and turns. So I think I'll let you come in here because then it really took a lot of bouncing.
Yeah, it was a very interesting one. So we did the IPM based on the medical information that Athens had released, no lifting over 30 pounds. But Felicia said a good question that could have been asked much earlier is that, wait a minute, is this 30 pounds both arms or just 30 pounds of the right arm? Because that makes a difference. And so we went through everything and we went through the job details, and this was a working lead position. And I think we pretty much know what a working lead means. It doesn't mean you're just a supervisor of people, it's you're working. And we very much emphasized, the director very much emphasized that we can handle the 30 pounds because there's really not a lot that goes over 30 pounds in this job. And we're always in a team. And so there's always assistance that can be obtained. So anything 50 pounds or more, like Cal OSHA, is a 2-person lift anyway. Okay, easy to do. It's not like a custodian that's working off on their own or a maintenance worker, but this was a team of people that were always working together. So the employee was never going to be in a position of where he'd have to lift anything more than 30 pounds because there was always assistance. And it wasn't anything special for him. It was given to everybody did this, a really good working environment. And so then I immediately did the DWC notice of offer for modified work because there were some things that they had adjusted and changes that they'd made And so then when we sent the offer, then the employee
Oh,
comes,
yeah, let me
oh,
just,
okay.
because I wrote them down. So then two things happened after that, and then I'll let you continue. The claims team sent the cut and paste from the actual permanent stationary report. What the work restrictions really were: no lifting, pushing, or pulling more than 30 pounds with the right arm. That was the first clarification that came after the IPM. The second clarification was the employee wrote an email after he got the letter offer, and he added the language to the employer offer. Employees' modified duties will be limited to supervisory and light duty work that does not require repetitive or overhead use of the injured shoulder or any operation of powered landscape equipment. Okay,
It's
back
like,
to you.
what? Where did that come from?
Back to you.
Yeah. So we had no knowledge at the IPM. And even when I queried of the employee and the director as far as anything else that you're having challenges with or things are not being performed, and there was no mention of any of this as far as the powered tools or no use, and definitely not only a supervisory position instead of a working lead. And so it was like, oh my gosh, I was like, where did this come from? And so it was just simply a matter where we didn't get all the medical information for whatever reasons. I'm not really clear, but so we are doing a follow-up IPM next week to clarify, because he probably cannot be accommodated, even though he was given temporary accommodation, because these are long-term limitations that, no, it's a working lead position. It's not supervisory. And so that changes the whole job classification anyway, which they don't have. And it would be a promotional position. So there's a whole lot of protocol that gets involved in that. And I don't know how we could have managed that any differently, quite frankly. I think we managed it well. It's just that we didn't have all the information. And
I think
one,
too, one of the things that you and I both feel is if you've got temporary work restrictions over 9 months, 12 months, and they haven't changed, those probably are your permanent work restrictions that
yeah,
you're working with. And that is why some of the districts, which I think is a really good idea, they move them in their temporary return to work policy, whether they do accommodated duty for 60 plus 60, which is real common, or I have one district that does 90 plus 90 to 180. They're moving them around. And even though that's more work, they do that because they want to create the idea that this is not my new job. This is temporary duties, temporary
mhm,
transitional work. Because in this particular instance, I don't know about what you felt. It seemed like the employee really got the idea that this was his new job forever. And why
yeah,
would he not? Because he got left there for a year without any conversation about there being any problem.
yeah, yeah. So there are a couple of things I want to say about this. And again, I've been doing this kind of work been working with employees with medical conditions in the workplace under workers' comp since I'm really dating myself here, 1982, I think it
Yeah,
is.
1980 for me.
Yeah, yeah. And then the ADA came in 1990. And I had some very interesting cases early in that process. And so the EEOC has always been clear. It's not a written policy. 180 days, folks, is really your max. Because again, as Felicia just said, if you've got something that's going greater than 6 months, this is long term. Whether or not they've reached maximum medical improvement, but these are probably not going to change. So that's one thing. And the other part of that then is because back in the early days, a lot of long-term temporary accommodations were given because people didn't know what to do, quite frankly. And then when they tried to make changes, well, now we have all these protections. It's just, you've lived with it for a year or two. So why
Mhm.
tell me what the undue hardship is here? You've already been doing it. So it's almost an automatic given that if you've done it that long, you can live with it. And unfortunately, that's what this one district is dealing with now. How are we going to remedy
Mhm.
this? The other thing about that, though, and a lot of you have heard me say this, I'm going to repeat it again. Really do stick to that 60 and 60 or 90, whatever your policy might be, because I know we want to see people return to work following an injury or medical condition, but sometimes returning to work too soon without time for recovery and taking some time off from work can prolong recovery. And in this case, it took him a year plus to reach maximum medical improvement. It was like 15 months, I think, before he became MMI, and he continued working all the time. To me, that tells me that working is not a good thing here. It could actually be prolonging recovery and also not allowing the employee to recover to a better level. So that's the other downside of not only does it become a business practice in a way of doing business, but it also can be impacting someone's ability to actually recover to a better level. I've seen that a lot, where people, they just don't get better. So I think we better stop working, quite frankly. Give yourself a chance to heal, take advantage of the therapy and all that kind of good stuff.
And there was heavy union involvement, if I recall, in this case too, because they were very alarmed. If they said, if you're going to tell us that you can't accommodate this employee now after all of this, I just felt like litigation, and that's over in the civil world,
Yeah.
not in my world. I just felt it was coming, right?
Yeah, yeah, yeah. So final word on that is really define your temporary accommodation process with a specific timeline, and also because of how continuing to work can actually be extending the recovery time. So yeah. So too much, too long, way too far. Yeah.
Mhm.
Okay, so number 3, progressive medical conditions. Like I've said, I've encountered some very unique situations throughout my entire career, but particularly in the last 5 years. And so I have 2 different school districts where the person has seizures and has had them. They put in emergency plans in case she has one, what happens. And yet, and she was accommodated for a long time. I think the last IPM was in 2018. But just since school started, the employee had already experienced like 3 or 5, I'm not remembering right off the head, seizures at work. And so she's a teacher. It would end up that she would leave the classroom unexpected in the care of her instructional assistants, which is a no-no, and then just be out of it for a little while. And so because it was happening much increased frequency in spite of other protections put into place, we met again. And so come up with some recommendations, and I'll go on to the other case first because they both involve teachers. The other person, 24-year employee, she still looks relatively young, kinder teacher. She started showing up with some problems about a year or so ago. They moved her from kinder to second, and then for this year, she got moved to 5th grade. She has Huntington's disease. And if you know anything about Huntington's disease, it's a progressive and very debilitating condition. And so it's okay. And she has a family history of it. And so here's this really loved, valued teacher. Her sister works in the same district. But it was clear that she wasn't able to function. Parents were asking for students to be moved out of her classroom, et cetera. And so I did a lot of consultation with the Job Accommodation Network on these kinds of things, because to some degree they can do the job, but they can't do it the same way. And there's really no effective accommodations that can be implemented to prevent or manage some of these situations. In the second situation, the cognitive abilities were clearly showing up. Her demeanor, she was oftentimes described as being mean and speaking really to students. She did really well in professional meetings like our IPM, but the documentation has just built up. So Job Accommodation Network said that before you consider termination, move the person to a lesser responsible position. It's just it's an unfortunate but fact of life then, is that we can't just terminate people because they have these debilitating conditions, but moving them so that it wouldn't be the primary teacher, but maybe a support person. I'm not sure what's happened in the first case yet. I put that information out there because they both happened in the same week. But I do know that rather than taking her off of work, and she'd already been off work for a good part of last academic year because of her symptoms. And at that point, it was all performance. She had not disclosed the medical condition. So that was the other thing, is that this is a performance issue. We'll use the accommodation process to bring up performance, but if we can't, it will go back to the performance issue. And I know the school board was ready to take action on that. And I said, I think you got to do a little bit more here, according to the Job Accommodation Network. So she hasn't moved into a support position. We're going to check back before the end of the calendar year to see if her symptoms have progressed. And I'm in the process of writing to her doctor now to say, please help us understand, because there's 3 distinct phases. And so where is she? She clearly has moved over to stage 2, but how much sooner before she really becomes more debilitated? And both have retirement in the not too long future, but at the same time, that's a scary notion too.
It's such a devastating diagnosis. In both of those cases, they have devastating non-industrial conditions going on because I've known about the one case that's been happening. It started after I started and has been going on for years. And both of them love their jobs as teachers. And that is what disability retirement is for too. If you get to this point, that is exactly why we have it.
Yeah, yeah, yeah. So those both very difficult situations. We're still monitoring and managing, and but yeah, we got to do our due diligence there even as well. Yeah, we've got about 15 minutes left, and so let's get into our EEOC cases. And here's some interesting developments there.
Yes, the first case involves Walmart. This was an ex-Walmart worker with what they called unexcused concussion-related absences, and the EEOC felt they may show a bias, and they felt that this case is one of many to center on the question of when and how an employer becomes aware of an employee's need for a reasonable accommodation. Kind of circles back to our question, our very first question about what is knowledge, right? The judge held that Walmart failed to accommodate a personal shopper's disability after she sustained injuries in an accident, non-work related accident, and the judge felt they violated the ADA. The worker's injuries required surgery, and Walmart granted unpaid leave. That was their accommodation for that. Then she came back to work. She returned to work and she was assigned for modified duty to the store's photo desk due to weightlifting limitations that she had before resuming her normal duties. Shortly after this period, a non-work related concussion situation caused the employee to miss work again. And the employee had run out of all accrued sick time and vacation time, but asked Walmart to excuse 3 concussion related absences. And Walmart allegedly, in this case, refused to do so and fired her because she had, quote, too many absences, unquote, absenteeism problem, right? She alleged disability discrimination and failure to accommodate and retaliation. And the judge denied Walmart's motion for a summary judgment to get out of all the claims. The takeaway for this claim, or that this case, which is very interesting, under the ADA, what they were saying is employers may not discriminate against employees who are qualified to perform their job's essential functions with or without an accommodation. And the first step, like we talked about in the interactive process, is the employee's request for an accommodation. In this case, there was a lot of back and forth arguing over did she really request an accommodation? And it goes back to our first example. They don't need to say the words. The employee said she made a request in text to her supervisors and later in emails to the store manager asking for the absences due to the concussion to be forgiven or to allow her to not be terminated. And the court feels that may have been notice right there. That's knowledge of a possible need for an accommodation. Now, Walmart says, no, that's not enough. The employee alleged that she did need the days to go to the hospital, and she put that in her email for treatment for the concussion. And one of the things that they mentioned at the EEOC, the court mentioned, they viewed evidence in the light most favorable to the employee. So I thought that was very interesting because that's how the way workers' comp works too. All judges and all courts in workers' comp injuries view all evidence in light most favorable to the employee. It leans towards the employee. So it was very interesting to see that the EEOC language was the same.
Yeah, yeah. Again, I go back to something that we talked about earlier as well, is that employers are the ones who are supposed to be informed about the applicable laws to their particular business, and including human resources or risk management. And so you're the big brother as an employer, and you're the one who should know. Employees can't be expected to know the nuances of all these potentially applicable laws like the ADA. Did they request an accommodation? No, but you have knowledge of a medical condition. Concussions, hospital, I'm sorry.
Because that's the thing they're arguing over. Was it enough? They felt that she didn't say the words in accommodation, but who knows those words, right? If you don't work in
Yeah,
our world, how do you know those words?
yeah. And an organization, particularly as big as Walmart, again, but then that's where we always say that at the local level, that a store site manager or something like that may not always know these things, and that's why
Right.
it's
The store
important.
manager that fired her
Mhm.
for absenteeism. And they
Mhm.
never did an IPM. They didn't
Yeah,
meet with her.
yeah, very interesting. So again, knowledge, if you, anything inkles of medical condition or hospitalization or anything, that's knowledge. So,
Never get in trouble if you err on the side of meeting too much.
and
Right.
certainly an IPM is far less expensive than a major lawsuit. Yeah. So tell us about the wine company. We'll finish up on that one.
The last EEOC case that I thought was interesting was the Cheerwine Bottling Company, and they fired an employee because of this is a non-industrial condition because of her MS, but I liked the case facts despite a doctor's clearance. So the company ran afoul of the ADA in this claim when they required the employee take a physical ability test designed to elicit private medical information. That's what the lawsuit alleges. This would be similar if you guys that do pre-employment, we do them post-offer pre-employment for all employees. If you're going to do it, you have to do it for all employees. And we are very careful about what information we get from those. And
Mhm.
we're not supposed to be eliciting private medical information from those tests, and those we'll talk about that in a little bit more. And we do those. This is a case with an existing employee. Cheerwine Bottling Company allegedly violated the ADA when they required an employee with MS to submit to what they called a medical exam, and then they fired her after they received the results. That's the allegations in the lawsuit. The employee was a store merchandiser at this is like a soft drink manufacturer in North Carolina. And she walked with a limp due to MS medication that was causing deterioration in her hip cartilage. 6 weeks into the job, so she was already hired. She's already working and she's doing this store merchandising job. She was required to take a physical agility test, making her the only new hire to undergo this test during her 90-day probationary period. This is a big red flag, you guys. They like signaled like only her, just put her. Test results noted that she had decreased strength in her hip, gait, and difficulty with squatting, but that she met the requirements to do the job. After the test, Cheerwine placed the employee on unpaid leave and they fired her at the same time. And the next day, she brought in a doctor's note clearing her to return to work. But the employer rejected the note and told her she'd already been terminated. In other words, too late to have any more conversations. The EEOC sued Cheerwine, alleging it fired her because of her disability in violation of the ADA. And EEOC also said that the physical agilities test was had impermissible medical evidence under the ADA because she was unlawfully asked about her MS condition and asked to reveal information about her limp and her medication. And I think they took her blood pressure and measured her range of motion. And then they documented this and gave all this information to the employers, right? Yikes. Under the ADA, an employer can require a current employee to submit to a medical examination only if it's job related and consistent with their business necessity. Physical agilities tests are generally not considered medical exams and they should not exceed their scope, where they're asking a lot of information about private medical conditions and they're measuring range of motion or taking blood tests or measuring blood pressure. That's not supposed to be the scope of this. So I thought it was very interesting. And it's the same when you think about our post-offer pre-employment physicals for our districts that do this as part of their board policy. You're doing a physical, and then if they have lifting, pushing, or pulling, then you're doing a specific test for that. And you're right, this is before they're hired. And as we say, they're either cleared or not cleared. And if they're not cleared, typically they might have limitations, and then you need to have an IPM even
Mhm.
before they've even started working because you've made them an offer and then apparently we have a problem, right? So
Yes.
you can do IPMs on your new employees that haven't even started yet before
Mhm.
their start date, right?
Yeah.
Because of
Yeah.
the pre-employment physicals.
Yeah, yeah. And it's not used often by districts, but I definitely have been involved in the new hire IPM to clarify. And sometimes we've been successful in accommodating them, and sometimes we've not been successful. But again, that IPM is your surefire way of defense, first
Mhm.
step. To show that you've engaged and you explored the issues, and here's the plan of action that's come up. And again, even if you can't accommodate, then it's a great way to demonstrate that you've looked at all the information and considered all the options
Mhm.
potentially
Well,
available.
I find it so interesting too that rather than having an interactive process meeting with her, somebody observed her limping, right, or having difficulty. And then the way they chose to handle this with an existing employee who's there already is send her for a test, not a physical, not a medical exam, not a fit for duty with a doctor, not that, right? Just this test, and then asked a lot of information, private medical information in this test, and then use the results of the test to fire her, but did not have an IPM.
Yeah,
Wow.
yeah. Missteps all the way around.
Mhm.
Yeah, in fact, that's another guidance that I learned very early on from the EEOC in the early days of the ADA implementation, that when you've got concerns like this, hold the IPM first. Don't just send somebody off for a fitness for duty or an exam, because again, there may be, well, there's not always knowledge gained, but there may be information
Mhm.
gained in ways that things can be worked out differently. And the other thing that goes along with that, not only having the IPM, there was another case where the employer sent her out to an IPM, a fitness for duty, then had the IPM, and the employee was totally confused as to what was going on and why was this happening. And it was a long-term employee, but she developed a medical condition. And so the steps to take would be first an IPM, try to
Mhm.
go through the employee's existing medical provider, but we probably all have experienced medical
Mhm.
providers not involved with occupational injuries or disability in the workplace oftentimes don't know how to respond to some of our questions, and then go to a fitness for duty. So it elongates the process, but again, legally, it's sure much more defensible and less likely to cost you money in the long run. And then you're doing right by the employee too. Again, this is supposed to be a collaborative, cooperative process, and to work together, not against each other.
And
Uh,
sometimes we've seen those cases where after the IPM, they don't need the fitness for duty, which they
exactly.
really thought they needed. But once they have the meeting, they don't need it because they have more information that they need, or the employee provides information in the process and in the meeting that helps them with what their
Yeah.
question.
Yeah, yeah, and that's why when I'm involved in trying to work with the employee's medical provider, I can do so in a confidential way that can ensure that information not appropriate to the questions at hand are not shared inadvertently. But also, I customize the questionnaire to make sure that we're really honing in on just how are the essential functions impacted, how's their ability to be at work, stay at work, perform the work impacted, and then again, where are they in their state of recovery and long-term, short-term, et cetera. And so I always customize those questions to make sure we're really targeting the right information and we don't run into trouble of
Mhm.
information disclosed inappropriately.
And
Yep.
certainly from a work comp perspective, we see it so much because we send all employees will send them a medical release to get their private medical records. And with our population, we hardly ever get those back. They are like, what? Number one, why do you want my private medical records? That's number one. And number two, what are you going to do with it? Because we
Yeah.
don't really explain that. We just send it off in the packet. It goes to everybody. We use it obviously for possible apportionment if you've had prior injuries to that body part. But yeah, a lot of employees are very resistant to sign that or give that back.
Yeah, there we did it. We talked about word of mouth knowledge is the key. We talked about please track your temporary accommodations and because of the pitfalls that you can encounter when it goes on way too long. And then also how to manage those progressive conditions. And we don't jump right to termination, but instead, okay, what other options exist for the employee to continue working, but maybe with less responsibility. And then lastly, we've seen missteps of even big companies like Walmart and not knowing or not doing due diligence, I guess, according to the proper steps. Anything else to add, Felicia?
It's tough to have trained all your supervisors and managers to know what HR is supposed to know. That's a big job, and especially when new people are coming in, people are retiring and resigning, it's hard to make sure that they all get information on this.
Yeah, yeah. Yeah, and so that's where, as HR professionals and risk management professionals, it's just so important you keep a pulse of what's going on in your districts and making sure that you're making your face known and your services available. Because we don't want supervisors and managers out in the field or wherever they might be going it alone. It's too risky, it's too costly, and legally it's a what do I want to say? It could be a nightmare.
Yeah.
Thank you again, everyone. Thank you again, Felicia, for working with me on this podcast. Like I said, I'm going to miss you horribly, as I'm sure all of our districts will. And watch for the recording. And again, we've got the dates out there for November and December, so you can pre-register and be notified of when the events are happening. I'm not anticipating we're going to have any changes based on our last conversation, Felicia, but you never know. But we will do it and keep this information going. So hope you enjoyed it, everyone. Thank you for being here. And again, share the recording when you get it. Use it as a learning opportunity. Thanks, Tina. That's sweet. Okay, bye.
Happy
We'll
fall,
see you.
everyone.
Yep. Happy Thanksgiving. Kathleen, thank you.
Love the floating hearts.
Yes, yes. Very cool.
Floating heart. Oh my God.